You're listening to the Cyberwire Network, powered by N2K.
How many discounts does USAA Auto Insurance offer? Too many to say here. Multi-vehicle discount, safe driver discount, new vehicle discount, storage discount, legacy.
How many discounts will you stack up? Visit USAA.com/auto discounts. Restrictions apply.
I think you're going to have states that are either maybe some of the larger states or maybe states that have, maybe great cybersecurity programs in their colleges, that are recognized nationally. They may fare very well under this idea of more responsibility being given to them because they've got the resources to deal with it. My concern is, the have-nots, as you kind of call it. There's other states where they may not have as accessible to the same type of resources, the same types of skill sets. And that's, I think, going to create an imbalance.
Hello, everyone, and welcome to Caveat, N2K Cyberwire's privacy, surveillance, law, and policy podcast. I'm Dave Bittner, and joining me is my co-host Ben Yellen from the University of Maryland Center for Cyber Health and Hazard Strategies. Hey there, Ben.
Hello, Dave.
On today's show, Ben has the story of a Virginia case relating to reverse keyword searches. I've got a highly unusual move by the DOJ against Maryland's district courts. And later in the show, my conversation with Gary Bartlett, former federal CIO and Air Force Cyber Operations Officer and current public sector CTO at Illumio. We're discussing how the Fed's approach to cybersecurity leaves some states much more at risk than others. While this show covers legal topics and Ben is a lawyer, the views expressed do not constitute legal advice. For official legal advice on any of the topics we cover, please contact your attorney. All right, Ben, we got some good things to cover here today. You want to start things off for us?
Sure. So I got my story from the Electronic Frontier Foundation. They are involved in a Virginia criminal case. They released their amicus brief in this case, along with the ACLU. And this relates to reverse keyword search warrants. So background on the case, it was actually a pretty prominent, famous case. A guy by the name of Clements has been charged and convicted of pushing a woman out of his car. He pretended to be an Uber driver, lured her in, pushed her out. It turns out she was like a Ukrainian immigrant. It was a really tragic story. She lived, miraculously, but he was charged and convicted. One of the grounds for his appeal is that some of the evidence used to obtain the conviction came from a reverse keyword search. The problem here, Dave, is I can't find any information on what he was alleged to have searched. I'm wondering if they keep that private. I can use my imagination to figure out what it was, and maybe some of our listeners who are familiar with this case might know what it was. All of the public sources just say, we did a thorough investigation and found out that he was searching for something in a Google search box, and that ended up being incriminating, and that helped lead to his conviction. Unfortunately, we don't know exactly what he was searching in the Google box, but I do think that's kind of beside the point here. So a reverse keyword search warrant is when the government goes to your Googles of the world, or in case you use other search engines, which increasingly more people do because Google kind of sucks now. So, maybe you're using ChatGPT or maybe you're using Microsoft Copilot or something, but this was a Google search. The government goes to Google and says, within this particular time period, under these parameters, who in this geographical area by ISP address searched for X? And X could be anything that might be incriminating in a criminal trial. So who searched for CSAM? Who searched for how to push an old lady out of a car?
Right.
Who searched for how to leave a crime scene without leaving DNA evidence?
Right.
What happened at the trial court level is the criminal defendant raised this argument, and the court said that, reverse keyword searches do violate a person's reasonable expectation of privacy. The use of that search warrant in this case was reasonable under the circumstances, given the severity of the crime. So if you weigh the competing interests here, the need to convict this guy who did something rather heinous against his personal privacy interests. The case is now on appeal, and what the Electronic Frontier Foundation and the ACLU are arguing is pretty much regardless of the circumstances of the particular case, this type of search warrant raises significant constitutional problems. So their case kind of boils down to the following. They think that these types of search queries are a form of constitutionally protected speech. So the act of searching something online is an expressive activity. It's a way to receive information. People could be searching not so kosher things for completely innocent reasons. You could be searching how to cover up the scene of a crime because you're writing a mystery novel.
Right.
Which I think is critically important. And it is a form of expressive activity. People could use it for literary works, artistic works, political speech. There's the potential for a chilling effect. If you know that searches might be monitored, then people could be deterred from seeking information on sensitive topics. So if I wanted to search something about an embarrassing health condition, I might be reluctant to do so because I could be concerned that it could be used against me in a criminal proceeding. And there's some other case law that talks about that chilling effect. They also draw parallels to the Carpenter case. So in that case, Supreme Court ruled that accessing historical cell site location data without a warrant violates the Fourth Amendment.
Everything comes back to Carpenter.
It all comes back to Carpenter. And basically, like, the parallel here is that you're able to piece together a lot of personal information on what is ostensibly just metadata. But given the breadth and depth of the information you can learn, just like in Carpenter, this type of search is overbroad. In this case in particular, the warrant was based on a simple hunch. It was not something that they could prove in a court of law that they had probable cause to do. You never have any individualized suspicion. So you are searching every single user who used that search term. So it kind of resembles the type of general warrants that the Fourth Amendment was designed to protect us against.
Right. Let's go through this neighborhood and search everybody's house.
Right, and see what we can find.
Yeah.
And in that case, it's also similar to the type of geofence warrants that we've talked about, like who was in this particular area at this particular time.
Right.
The reason I think this goes beyond geofence warrants is just how broad it is. Because at least with geofence warrants, you are constrained by the physical location. Now, there are a lot of constitutional problems there because people could be at a physical location for completely innocent reasons and they shouldn't be caught up in this dragnet. And again, that's very controversial. But reverse keyword searches go beyond that. Anyone in the world could be searching for something on Google, not just for the offensive search term, but for literally anything. And they are caught up in this dragnet because to find the needle in the haystack, you have to search the entire haystack. And that's something that's particularly constitutionally problematic. So what EFF says is the only way these types of searches should ever be constitutionally permissible are if the person searched something very specific and uncommon. So like an actual physical address that no one else would be searching, to have stricter time constraints and minimization protocols, and then greater judicial oversight with deleting data that wasn't necessary for this search. So I've been fascinated by reverse keyword searches for a while. It's a really interesting case. And I also, and I'll stop after I say this, I promise. I think this has become more interesting because of generative AI. Because searches are getting a little bit more sophisticated. I don't know about you, Dave, but like for general knowledge searches, if I want to know like what time of year is most common for severe thunderstorms in Maryland, I'm not going to Google anymore. I'm asking ChatGPT. And I'm also going to be probably having a conversation with ChatGPT. It's like, okay, well, they tell me it's July and August. Well, what makes it July and August? Now, imagine if this was a conversation not about the weather in Maryland, but about something incriminating.
How do I hide a body?
Exactly.
Yeah.
I think that is going to be potentially a greater constitutional concern than what you put in a traditional Google search bar.
Okay, I have many questions.
All right, yeah, I was talking for a long time. Sorry.
It's okay. So the first thing that made me pause as you were describing this was the correct me if I'm wrong here. It was the court saying that we recognize there's a constitutional issue here, but in this case, it was so important to the case that we're going to allow it. And that sort of malleability of the rules gave me pause.
Welcome to Fourth Amendment jurisprudence, my friend.
Okay.
So there are a couple of ways which the deck is kind of stacked against criminal defendants. The first is the good faith exception, which we've talked about.
Yeah.
If the rules are kind of unclear, even if the court comes out in that case and says all geofence warrants are unconstitutional, they're unlikely to vacate that conviction in that case because when the police were conducting that investigation, they were doing so with a good faith understanding of what the law was at the time. That was before geofence warrants were declared unconstitutional, if that makes sense. So they were acting in good faith. The other thing is the Fourth Amendment doesn't prohibit all searches and seizures or even all searches and seizures done not pursuant to a warrant. It prohibits unreasonable searches and seizures.
Mm-hmm.
So that question of reasonability gets at competing interests. Assuming that you've established that there has been a Fourth Amendment search, which we have established that in this case, is that search reasonable? Well, you have to look at the context of the search. Here, I think the search itself is problematic, but then when you look at the competing interests, we have this dangerous criminal. This might be our only chance to lock him up. Compare that to the invasion of privacy, it does give judges a little subjective leeway to come to their own conclusions. That's just the way reasonableness works.
Right. So the other thing that I'm curious about is, we were talking about kind of the guardrails put on these reverse keyword warrants. I mean, suppose, one day Ben Yelin is found, dead on the sidewalk out in front of his house. And the police, assume that there was foul play involved, right?
They better, yeah.
Right. So they go to Google and they say, I want to know everyone who searched for Ben Yelin's address in the last 24 hours.
Mm-hmm.
I want everyone who searched Ben Yelin's name in the last 24 hours.
People could just be interested in my views on legal issues through the Caveat podcast.
Right.
Even if they weren't trying to murder me, and all of those people are caught up in the dragnet.
Okay, so that's what I'm getting at. So the specificity of the address, let's say, because that's where you were found,
Mm-hmm.
is that likely to be more allowable than the broad search just on your name?
I think so, because I think at least from EFF's perspective, the more you can narrow it in to something specific, the more it aligns with Fourth Amendment jurisprudence and what we intend the Fourth Amendment to be. The Fourth Amendment is first and foremost about specificity. We're looking for this thing or this person in this location. The closer you can get to that, the more likely you are to pass Fourth Amendment muster.
Right.
The further away from that you start to get into the world of general warrants, which is, let's go to Dave's house and rummage through his clothes and his drawers and see what we can find.
Yeah.
And whatever it is, whether it's illegal handgun or some dirty writings that we've founded in his journals.
My collection of embarrassing erotic poetry.
Right, which, we all know that exists somewhere.
Sure.
Whatever it is, we're going to use that to prosecute you.
Right.
And the more you can focus on specificity, I think what EFF is saying is, but they'd rather not have reverse keyword searches at all. But if we're going to have them, the court should really focus on that level of specificity. Do we have a specific place being searched? Is the time period narrow enough where we're not going to catch a huge dragnet of people? Because as popular as I'd like to think I am, if somebody was trying to murder me, I would guess that not that many people in the last 24 hours, for example, have searched Ben Yelin on Google.
Right.
But maybe a decent amount of people have in the last 365 days. And so those people get caught up in the dragnet.
Right. Where do you suppose this goes next?
Well, it is going to the highest court in the state of Virginia, the Virginia Supreme Court, where they're going to consider these issues. Right now, it's a really unsettled area of the law. I think it's going to hew closely to the geofence warrants cases, where Chattree, which was also a Virginia case that we've talked about, uncovered some problems with geofence warrants. And perhaps at some point, we're going to have a case that makes it up to the Supreme Court.
Oh.
So it's a long, we're not quite on that path yet. We might have to have conflicting cases. There have only been a few criminal convictions that have been sustained based on these reverse keyword searches. So we're just kind of in the early stages of case law on this. And
I can't believe I'm asking this, but is because this is the effect you've had on me. Is this one of those fruit of the poisonous tree things where if they find that this particular bit of evidence is no good, the whole case gets thrown out, or where they still have enough other stuff potentially on the guy?
it depends on how much of the other stuff would have been discovered independently. But if, like, let's say you get the reverse keyword search, that leads you to a person's house, and in that person's house, you find illicit material. If that original reverse keyword search is unconstitutional, anything that was gleaned from that original unconstitutional search is fruit of the poisonous tree and cannot be introduced at trial. So anything downstream from that. Now, if this is used among a bunch of other investigative tactics, and this is just one piece of evidence, then maybe the fruit of the poisonous tree doesn't apply. If everything else would have been found independently, if you give law enforcement enough leeway to conduct an investigation.
Right. How many years into this are we, Ben? And I'm starting to know legal lingo.
Thinking like a lawyer. It's not too late for law school, Dave.
I don't know how I feel.
We'd love to
about
have
this.
you.
Oh, yeah, that'd be great.
Would you like to
Sign me
go
up.
in hundreds of thousands of dollars in debt
Yeah,
to learn a bunch of esoteric?
that's what I need. I need a JD after my name.
Darn tootin'.
Yeah. All right, interesting stuff, and we'll have a link to that story in the show notes. Let's take a quick break here to hear from our sponsor. We will be right back. Krogel is AI built for the enterprise SOC. Fully private, schema-free, and capable of running in sensitive, air-gapped environments, Krogel autonomously investigates thousands of alerts weekly, correlating insights across your tools without data leaving your perimeter. Designed for high availability across geographies, it delivers context-aware, auditable decisions aligned to your workflows. Krogel empowers analysts to act faster and focus on critical threats, replacing repetitive triage with intelligent automation to help your SOC operate at scale with precision and control. Learn more at Krogel.com. That's CROGL.com. My story this week is also kind of fascinating and perhaps a little more general than the kinds of things that we talk about. But quite honestly, I put this in here because I just really want to know what you think about this.
Yeah.
So I figure if I do, our audience likely does as well. So this is a case where the Department of Justice has filed a lawsuit against, wait for it, the entire Federal District Court of Maryland.
Yep.
You want to unpack this, Ben? You'll probably do a better job than me.
Sure. So the U.S. District Court of Maryland has 15 judges, and they have all been sued by the United States Department of Justice under Attorney General Pam Bondi. Basically, what happened is the district court put a hold on the deportation of a bunch of individuals who were trying to assert their habeas corpus rights. So habeas corpus is a constitutional protection. Literally translates in Latin to "you have the body," which basically is a way for people to challenge the circumstances around their own confinement. So sometime in May, the chief judge of this district court ordered a 48-hour pause in every single case where an individual migrant had petitioned to try to block their removal from the U.S. with a habeas petition.
Okay.
And at least according to one law professor who's quoted here, the reason they did this is that there had been so many habeas petitions through so many people that courts needed time to consider all of these requests individually. And as we saw from the Kilmer Abrego Garcia case, once somebody's out of the country, it becomes a lot harder to litigate this in our court system.
I see.
And that person was deported through administrative error and spent months in an El Salvadorian prison.
Yeah.
What this lawsuit alleges is that this undermined the authority of the executive branch to carry out deportation proceedings under their Article 2 powers. They're saying this is a form of, quote, judicial interference in executive prerogatives. I think this is an extremely aggressive action from the DOJ. It is highly unusual. It's not generally the way we resolve these types of disputes. What should have happened here is that the DOJ should have appealed the decision of the chief judge to the United States Court of Appeals in the Fourth Circuit, tried to obtain a stay on the chief judge's ruling. And if they did not obtain that, then petition up to the United States Supreme Court to see if they could obtain a stay. There are 6 conservative justices. There's a good chance they could have gotten a stay there. That would have been the remedy if they believed wholeheartedly that the district court had come to the wrong conclusion. It's highly unusual to file a lawsuit not just against this court in the abstract, but against each of the individual judges in their professional capacity.
Yeah.
Because it's so unusual, this is the type of case that I think could absolutely end up at the Supreme Court. Is this a proper cause of action from the Department of Justice? I personally think it is not, but I am not always aligned on all legal issues with our esteemed Supreme Court.
Yeah.
So they've surprised me on things like this in the past.
Help me understand this, because we have this single judge in Maryland who does the 48-hour pause, right? So why does the DOJ then come after every federal judge in Maryland, not just that one?
That's a great question. I think in their mind, it was the chief judge speaking on behalf of the entire 15-judge panel.
I see.
And seeing that I believe there were no dissents, at least to that order, the implication is that all 15 judges were on board. I don't know that that's a reasonable assumption at all, but that's what the Justice Department is assuming in their lawsuit.
And what's the effect of this lawsuit then?
I mean, the real worry is that courts of law in the United States are going to be hesitant to rule as they interpret the law in their jurisdiction for fear that they're going to get a punitive lawsuit for damages from the Department of Justice, and that they're going to be forced to waste their time litigating that case against the most powerful department in the country. That's really what concerns me here is generally all district courts have to worry about is that their cases are going to be appealed to the next highest court. That's customary. That's how our system is supposed to work. That's why we have this hierarchical system. But if they are concerned about being sued over individual decisions in their capacity as judges, then the entire house of cards holding up our judicial system collapses because people are going to be kind of looking behind their back as they make really monumental decisions that affect the interests of so many people in this country, and that's not the way it should be. You should be coming up with your best interpretation of the law given the facts at hand in that case, not cowering in fear because the Department of Justice is about to make your life hell for the next 12 months.
What do you make of the DOJ's assertion here that that Maryland overstepped their bounds?
So they are saying that there is precedent going back to the Bill Clinton presidency of the DOJ suing an entire court. So this is not, in their view, completely unprecedented. There was a case in the 1990s where then U.S. Attorney and now esteemed United States Senator Sheldon Whitehouse sued the entire court in Rhode Island over a rule about issuing subpoenas to attorneys. What this professor of law at Georgetown University said is, well, this is not completely unprecedented to sue a judge because we think the judge's action is wrong. It's certainly unusual and not the customary way of going about its business. And to add fuel to that fire, defending the district court panel is Paul Clements, who was, I believe, the Solicitor General in the George W. Bush administration. So a very conservative jurist, or a conservative lawyer, I should say. I don't think he was ever a jurist. The fact that he's taking up this case shows that I think there's some bipartisan pushback against what the Department of Justice is doing. Another interesting element of this is they can't hear this case in Maryland because it's a conflict of interest. So it's been moved to Virginia. A lot of other judges, retired judges who can say whatever they want at this point, now that they're retired,
Right.
have written a letter saying that this is a violation of the separation of powers. And I wonder if that's going to factor into the case as it makes its way through the federal court in Virginia.
Okay. And you think this could be on a collision course with the Supreme Court?
Definitely, especially if the Department of Justice wins the case at the district court level in Virginia, and if they win at the Fourth Circuit Court of Appeals. It's very possible that the judge who's been assigned this case in Virginia throws it out and says, we don't do cases like this. This is an abuse of power. Now, the DOJ would have the right to appeal that decision, and they could be the ones who take that up to the Supreme Court. And that's a course of action that might happen.
Wow. People are taking off the gloves.
Sure are. There are a lot of things that were customs that we just kind of never did, even though the tools were available to be used, especially from the executive branch. And as the executive branch has accumulated more power through administrations of both parties, I think they've been more emboldened to directly challenge the authority of judges, who they see as tyrannical, unelected, judicial tyrants who are going against the expressed will of the American people. But that's kind of the point of judges, at least according to our constitutional system, is they are supposed to be the guardrail against the passions of the legislative and executive branch. So it does undermine the role of the judicial branch to file a suit like this.
Yeah. All right. Well, time will tell. We'll see how this one plays out. It's a fascinating one. We'll have a link to that story in the show notes. Tell you what, let's take a quick break here to hear from our sponsor. We will be right back. Hey everybody, Dave here. I've talked about Delete Me before, and I'm still using it because it still works. It's been a few months now, and I'm just as impressed today as I was when I signed up. Delete Me keeps finding and removing my personal information from data broker sites, and they keep me updated with detailed reports, so I know exactly what's been taken down. I'm genuinely relieved knowing my privacy isn't something I have to worry about every day. The Delete Me team handles everything. It's the set it and forget it peace of mind. And it's not just for individuals. Delete Me also offers solutions for businesses, helping companies protect their employees' personal information and reduce exposure to social engineering and phishing threats. And right now, our listeners get a special deal, 20% off your Delete Me plan. Just go to joindeleteme.com/N2K and use promo code N2K at checkout. That's joindeleteme.com/N2K, code N2K. And we are back. Ben, I recently had the pleasure of speaking with Gary Bartlett. He is a former federal CIO and Air Force cyber operations officer. Currently, he's the public sector CTO at Illumio. And we're discussing how some of the changes in the federal approach to cybersecurity has left some states more at risk than others. Here's my conversation with Gary Bartlett.
There's a lot of talk about decentralization, pushing more down to the states, letting the states be more involved in dealing with, lots of things, from, all the things that FEMA normally takes care of, and now, with the approach to cybersecurity and cyber defensive actions. I think that when you look at the changes that are being made, the federal level, with a lot of downsizing and a lot of resources being let go, I think there may have been a little bit of an overreach as far as the amount of downsizing that occurred in the federal government. I think there was a lot of talent that was let go that maybe should have been retained. I do have a little bit of concern there, but it does offer up an opportunity for states. You've got oftentimes people that are looking for some sense of service, and those people may find a new home at the state level.
Yeah, I think it's common for people to say that the states are kind of the laboratories for the rest of the nation. Do you suppose that we'll see some opportunities for innovation or experimentation at the state level?
Absolutely. At least I hope so. I think that because states are oftentimes, less restricted by, lots of, onerous regulations and laws and those types of things. I think you're exactly right when you say that oftentimes you'll see a lot of innovation come out of different states. And hopefully, that's something that other states learn from. And then maybe even that translates into, lessons learned at the federal level.
As you consider the different states in the union, do you suppose that there are going to be haves and have-nots?
I do. And that's part of my concern about this delegation of responsibility down to the state levels. I think you're going to have states that are either maybe some of the larger states or maybe states that have, maybe great cybersecurity programs in their colleges, that are recognized nationally. They may fare very well under this idea of, more responsibility being given to them because they've got the resources to deal with it. My concern is, the have-nots, as you kind of call it. There's other states where they may not be have as accessible to the same type of resources, the same types of skill sets, and that's I think going to create an imbalance. And it actually causes me concern because attackers don't recognize state boundaries. They're not going to be worried about only going after the states that have resources. They're going to go after the weakest link, as it were. A lot of times, those same states may have some of the most critical infrastructure for the nation residing in those states. So it causes me pause. It gives me great pause and it causes me a little bit of concern.
Well, and I suppose, I mean, it's important to point out that with these cuts that we've seen at the federal level, certainly my understanding is they're not just passing the savings along to the states in terms of grants to empower them to take on these tasks. The states are going to have to look around and figure out how they're going to fund these things.
Yeah, absolutely. If I was seeing a whole bunch of money being thrown at the states, I might feel a little less unease. But as you referenced, that's not what we're seeing. They're looking for those cuts to be realized as savings. I think there's still going to be some continuation of existing grant programs out there, but I'm not sure that they're going to be enough to offset this new level of responsibility and the cost of inheriting that responsibility. So, I'm a little worried about how this is going to be funded. And again, money can't solve all the problems, right? There's got to be skill set. There's got to be, people available. So I think that there's going to be a disparity that's going to cause potentially some issues in the future.
What are some of the things that you think the states can do here going forward to best position themselves to handle these new challenges?
So one is that, and I have seen some reference to this, is I think the first thing states ought to be doing is looking to see, are there federal resources that they can, expertise that they can inherit, right? That they can hoover up a little, as it were, and hire as some of these people were being let go by the federal government, right? So they can go after that expertise. I think that's one. Number two, one thing that kind of works in the state's favor is states oftentimes do pretty good at cooperating with each other, right? When you think about all sorts of things when it comes to law enforcement agreements and those types of things, states I think are a little more nimble and oftentimes a little more willing and able to put in place cooperation agreements. So hopefully they'll look at forming coalitions from a cyber perspective, where they can do mutual aid and those types of things, so that if there are states out there that are having trouble getting resources, perhaps they can leverage the resources from a neighboring state that may have resources that could aid them.
I suppose one of the big issues here is that this approach injects a lot of uncertainty for a lot of for a lot of people. The funding, the personnel, even what the future holds, because we don't know what the next administration may do or not do in response to these changes, be they Republicans or Democrats. It strikes me that that level of uncertainty is, when it comes to cybersecurity, is not helpful.
No, and I don't think it is, right? I think that I would love to see more strategy, more guidance, more vision coming out of the current administration. If nothing else, to give the states a roadmap to kind of follow. or at least, some guidance on how they should be approaching this. But I am very concerned about this taking something that, from my perspective, is such a national threat, and from a strategic perspective, and breaking it up across, all the different states. Whether there's good guidance in place or not, trying to figure out how to coordinate, for 50 states, reaction to, some sort of attack that starts to spread nationally. I'm not sure how that's gonna fare.
Suppose you were a state CISO right now and you were faced with this situation. What sort of things would you be doing? What sort of meetings would you be having and planning would be taking place?
So I'd be doing a couple of things, and some of this I know they're already doing, right. But making sure that I'm having a good relationship with the local FBI office, right? Because obviously that they're going to be involved, from a threat analysis perspective, from an intelligence perspective, and any other agencies that I've got in my state that could help provide me some insight, some guidance about the types of threats I'm going to be facing. I would be quickly talking to other state CISOs to talk about, hey, how can we cooperate and graduate together here? What can we do to leverage each other's capabilities? How can we help each other? And then I'd be talking to my state legislatures and explaining that, hey, we've got this new huge responsibility that's coming down, that is suddenly becoming our responsibility. We're going to need some help, right? This can't be done with existing budgets and existing personnel. And this is something that, from a legislative perspective, is going to have to be addressed and addressed quickly.
Yeah, I wonder if the model that we see with things like the ISACs, if you have regional state cooperation agreements, and I'm sure some of that already exists, but to see those sorts of things enhanced or maybe even supercharged, you could see that as being a potential future.
Yeah, absolutely. And like I say, right, there are agreements I know that are in place. And when you see things like, how do, local police departments, from a state level, county level, cooperation agreements, you see, anytime there's an issue from a power perspective, right, a hurricane hits one state and you see resources surge to assist that state, so the states are used to cooperating, together like that. They may find it, they've been doing that in the past in the cyber realm, but they may realize that it's going to become much more important in the future because of this increased responsibility that's being delegated to them.
Ben, what do you think?
Really interesting. It's something that I pay attention to a lot, the disparity between states and how they can respond to cyber incidents.
Right.
Some states are very well positioned, particularly the bigger states that have the type of resources to fight against all different types of cyber threats. There are a lot of very small states in this country who could be the victim of cyber attacks who simply don't have those same type of resources. And that's a fault of our system of federalism. Theoretically, we should have a federal government that would protect the interest of all states, big states and small states. But if we're going to devolve those roles to the state, that's kind of the risk we're going to take.
Yeah. I've seen a lot of concern expressed, particularly over rural hospitals in underfunded states, that they could be sitting ducks here.
Yeah, it's not the best time to be a rural hospital.
For lots of reasons.
Yeah, exactly.
Lots of reasons. Let me ask you this, just bringing it back home, when you think about our home state, or my home state, your adopted state of Maryland, would we be considered a have or a have not when it comes to these sorts of resources?
I think we're more of a have than a have not. Maryland is not a huge state, but it is a medium-sized state, and I think with some hiccups here and there, the state has done a good job in anticipating cyber threats and putting together the government infrastructure to protect our state and local governments. So I'm gung-ho about the work that Maryland has done in this space so far, even though, we have 10 electoral votes and California has 54. So
right.
That represents the size of our difference.
Okay, got it. All right, well, again, our thanks to Gary Barlett from Illumio for joining us. We do appreciate him taking the time. You tune in to us here at Caveat Weekly. Now we'd love to hear from you. Your voice can help shape the future of N2K networks. Tell us what matters most to you by completing our annual audience survey. Your insights help us grow to better meet your needs. There's a link to the survey in our show notes. We're collecting your comments through August 31st. Thanks. Did you know Active Directory is targeted in 9 out of 10 cyber attacks? Once attackers get in, they can take control of your entire network. That's why Sempris created Purple Knight, the free security assessment tool that scans your Active Directory for hundreds of vulnerabilities and shows you how to fix them. Join thousands of IT pros using Purple Knight to stay ahead of threats. Download it now at sempris.com/purple-night. That's sempris.com/purple-night. And that is Caveat, brought to you by N2K Cyberwire. We'd love to hear from you. We're conducting our annual audience survey to learn more about our listeners. We're collecting your insights through the end of this summer. There's a link in the show notes. Please take a moment and check it out. This episode is produced by Liz Stokes. Our executive producer is Jennifer Iben. The show is mixed by Trey Hester. Peter Kilpie is our publisher. I'm Dave Bittner.
And I'm Ben Yellen.
Thanks for listening.
Hi, Kim Jones here. On CISO Perspectives, we get candid with the thinkers, doers, and trailblazers shaping cybersecurity leadership. No scripts, no sales pitches, just real stories and hard-earned lessons from folks who've been there. If you're looking to grow as a leader or just want to hear how others are navigating this ever-evolving field, listen to CISO Perspectives. It's your seat at the table.